afternoon, everyone. Call this meeting to order. Welcome to meeting number 7 of the House Common Standing Committee on Justice and Human Rights. Pursuant to the order of reference that you're all familiar with and the motion adopted on October 7th, the committee is meeting to study Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural places. Today's meeting is taking place in a hybrid format with notably MP Idlout joining us online. Pursuant to the standing orders, members attending in person in the room and remotely using the Zoom application. Avant de continuer, comme toujours, j'aimerais...
Before I proceed, as usual, I'd like to call on all participants in person to consult the guidelines on the cards on the tables in front of you. These measures are in place to prevent acoustic incidents and to protect the health and safety of all participants, including interpreters. There's a QR code on the card which sends you to a short awareness-building video.
Take a few comments, make a few comments for the benefits of the witnesses and the members. Please wait until I recognize you by name before speaking, and for those participating by video conference, MP Idlout, click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. For those on Zoom, at the bottom of the screen, you can find a selection tab for the appropriate channel for the interpretation, either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. Reminder that all comments should be directed through me, the chair. For the
members in the room, if you wish to take the floor, please raise your hands. For members on Zoom, please use the raise hand function, and the clerk of the committee to my left and I will do our utmost to keep the speaking order, and we'd like to thank you very much for your patience and your understanding in that regard.
The committee has graciously agreed to allow a couple of questions from MP Idlout at the end, so we'll move on. We'll go all the way to 3:30. We'll go to 4:35, and then just hold the rest for the next meeting of officials that I'll introduce then. Welcome, Minister. Welcome, guests. Appearing today, we have with us the Minister of Justice, the Honourable Sean Fraser, Shalene Curtis-McAuliffe, sous-ministre et sous-procureur général du Canada.
Who's the Senior Assistant Deputy Minister, Owen Ripley, the Senior Assistant Deputy Minister, and the Senior Counsel, Joan Wells.
Witnesses on the second hour. A reminder that for the presentation today, Minister, you have 5 minutes to present, and without further ado, I turn the floor over to you. Welcome.
Thank you very much, Mr. Chair. Members, it's a pleasure to be here with you today to discuss the Combating Hate Act, Bill C-9. Just to set the table, one of the things that I think we need to reflect upon as Canadians is that it's a great promise of this country that we have the ability to live freely, regardless of the color of our skin, the God that we pray to, or the person that we love. Sadly, too many Canadians are robbed of these basic freedoms, not necessarily by operation of law, but too often by virtue of being subjected to hate in their communities. One
of the true promises of our country is the ability for Canadians in this nation to enjoy rights and freedoms. Unfortunately, there are a number of examples of persons subject to discrimination and hatred.
Canada that's worsened, particularly since the end of the COVID-19 pandemic. And it manifests itself in very painful and very human ways. When you have the opportunity to talk to people who face discrimination, and let's be specific, it's not just discrimination. These are firebombs on our synagogues. There are desecrations of our National Holocaust Memorial. We have seen far too many people feel unsafe to practice their faith. But this, though we've seen certainly a troubling rise in anti-Semitism, is not limited to any one particular faith. I have had the opportunity to speak with members of the Muslim community, the Christian community, the Hindu community, the Sikh community, who tell me the great pain they go through when they're unable to live their lives freely, be who they are, and practice their faith in public. It doesn't take long when you start to have conversations with communities who are subjected to hate to realize it's not restricted to the religious context. When I talk to members of the queer community, they tell me that of course it's painful if they've personally been subjected to hate, but when they read stories in the news, quand ils lisent les histoires dans le journal,
when they read stories in the news, there's a lot of fear.
That they fear to even hold their loved one's hand for fear they may be subjected to violence in their communities. It's important that we do more than offer our words and our thoughts and prayers to people who've been subjected to hate, often violent actions of hate. That brings us to Bill C-9. We, of course, in the recent federal election campaign, made a commitment to add new offences to the criminal code, specifically to protect the ability primarily for people to participate in the activities at their religious institutions, the buildings, the churches, mosques, synagogues, mandirs. It's important that we realize hate is not limited to the doorsteps of our religious institutions. Though this bill includes the criminalization of intimidation of those who would attend the buildings or structures designed for identifiable groups, both intimidation and obstruction of those facilities, we've decided to go beyond that initial commitment and introduce a standalone crime of hate. This is meant to recognize that hate is throughout our communities, in our parks, in our streets, on our university campuses, in our grocery stores. And the way that this particular charge will operate is to lay over existing criminal offenses to recognize that there is an enhanced moral culpability when you commit a crime against a person on the basis of who they are. And it also recognizes that it is not just the individual victim who suffers consequences when they face an act of hate, but the impact reverberates throughout the entirety of a particular community, causing people to have extraordinarily difficult and traumatic experiences on the basis of immutable characteristics with which they were born. In addition to the intimidation and obstruction offence and this new standalone crime of hate, we have established an additional criminal offence, the willful promotion of hate through the use of hate symbols. Of course, the willful promotion of hate is an existing crime today, but this recognizes that sometimes the tool you use to commit a crime worsens the impact on the victim, and in this instance, on the entirety of a given community. Beyond the specific measures that we included amongst these new offences, we also heard loud and clear from law enforcement and from communities who've been subjected to hate that charges are not often laid. We know that there have been just shy of 5,000 hate crimes reported in 2023, the last year I've seen complete data. We expect the number is much, much larger. We've heard very clearly that there is difficulties when it comes to understanding clarity in the definition and also with the administrative process. For that reason, we've added clarifying language to codify the definition of hate and remove the requirement for the consent of the Attorney General. Je n'ai pas beaucoup de temps pour continuer la...
I don't have much time to continue with my opening remarks, but I hope that you'll have an opportunity to engage on this very important bill to protect minority communities and to ensure that all Canadians have the ability to live and enjoy their freedoms across all communities of our country. Thank you, Mr. Chairperson.
Merci, Monsieur le Ministre.
Thank you, Minister. We'll have enough time for 2 rounds, I believe, complete rounds, perhaps even a third round. Now, here's the order. Mr. Brock first, who'll be sharing some of his time with Mr. Gill, 6 minutes, Deputy Member House Father, and then Mr. Fortin, 6 minutes each. The floor is yours, sir.
Thank you, Chair. Minister Fraser, Justice officials, welcome to Justice Committee. Minister, since your government took office in 2015, crime in this country has been spiraling out of control. Violent crime up 55%, homicides up 30%, sex assaults up 76%, gun crime up 130%, and extortion shockingly up 330%. And yet, over the last 570 days, your government has only introduced 2 justice bills, C-63 and C-9, neither of which do anything to address the revolving door for violent repeat offenders. Why, Minister, after a year and a half, is your first legislative priority a bill that restricts free speech instead of protecting Canadians from violent repeat offenders?
Mr. Chair, with enormous respect to my colleague, I view the question to diminish the importance of the legislation that we're here to discuss today. Treating hate crimes as something less than urgent when members of affected communities are experiencing painful realities as a result of the hate that is lobbied upon them is not, in my view, the appropriate way to engage in this conversation. For the members' information, as we've discussed privately, we expect this fall, granted I've been in this position for a matter of a few months, most of which the House wasn't sitting, but this fall we have tabled the legislation we're here to discuss today. Within a matter of weeks, we will have one of the most comprehensive sets of reforms when it comes to the bail system and tougher sentences that our country has seen in many years, and a third bill before Christmas regarding intimate partner violence, sexual offences, and the role of victims in the process.
Thank you, Minister. I'm taking back my time.
Mr. Brock, I understand that the minister should be succinct in his answers, but just let him finish his thought.
Yes, I'm taking a look at the time it took me to pose the question, sir, and I've given him actually an extra 10 seconds to respond.
Go ahead.
Do I have my time?
Go ahead.
Thank you. Minister, in 2015, there were 382,000 incidents of violent crime. In 2024, there were almost 592,000. That's a 55% increase. Any way you slice it, Minister, is an objective fact that crime is worse now than it was in 2015. Are you willing to accept reality, or are you going to choose to remain oblivious to what's happening in this country?
Look, I can recognize that crime and violent crime is a problem in Canada. That's why we are moving forward with an ambitious legislative agenda that's going to toughen the criminal justice system. But it's important that we realize that there are additional solutions. In addition to our changes to the bail and sentencing regime that you'll see in a matter of weeks, you're also going to see investments in the front line with 1,000 new RCMP officers, 1,000 new border officials, and more prosecutors. But we also have a view of the long-term need to prevent crime by making investments upstream that will tackle opportunities to pull at-risk youth out of the system, to invest in supportive housing, and to deal with mental health and addictions. But I think it's clear that we need to take action to toughen Canada's criminal laws to punish people who commit serious crimes.
Minister, Conservatives have introduced nearly 20 justice and public safety bills this Parliament alone on bail reform, sex assault, intimate partner violence, and organized crime, amongst others, while your government has tabled just 2. Are you going to support any private member bills introduced by the Conservative Party?
We don't have a blanket rule on supporting or rejecting bills based on the source of those proposed legal changes. We instead consider independently each of the measures that are brought forward by members, regardless of which party they may come from. I've had productive conversations, not only with you as my critic, Mr. Brock, with our colleague, Mr. Caputo, as well, and I'm willing to work in good faith. If there are certain challenges that cause us to believe that the proposed reforms will not make communities safe or would be blatantly unconstitutional,
Thank you, Minister.
I will have challenges.
Thank you, Minister. Will you commit today to repealing the principle of restraint under Section 493.1 of the Criminal Code to stop repeat violent offenders from being released back onto our streets, yes or no?
You should expect to see changes to the way the principle of restraint is codified in the Criminal Code. I would point out that a repeal of the principle is not necessarily the appropriate language, given that the principle of restraint is recognized in common law and upheld by the Supreme Court of Canada.
So I'll take that as a no. Thank you, Minister.
With it, and we will be making changes.
Thank you, Minister. Last month, in response to the Conservative announcement of the Stand on Guard policy, you tweeted out, quote, "This isn't the Wild West, it's Canada." Around the same time that you tweeted out this tone-deaf statement, in Hamilton alone, more than 80 shots rang out at bars after they were closing, leaving 3 injured. In Toronto, a 19-year-old was shot and killed in a mall bathroom. 2 17-year-olds were charged. In Ottawa, a Jewish woman in her 70s was stabbed and sent to hospital just for being Jewish. In Calling Lake, Alberta, a man wanted on a Canada-wide arrest warrant was charged in a violent home invasion where the homeowner was shot and killed. If these and thousands of other crime stories that are happening around this country on a weekly basis aren't indicative of the Wild West, what would meet your definition, sir?
This is an important conversation. Canadians should know that they have the right to defend themselves under the law in their homes if they are faced with such circumstances as you've described. And they have the ability to use force to do so when it is reasonably necessary. Jurisdictions that have adopted the proposal that you've suggested have not become more safe and have created new dangers. Just a few weeks ago in Texas, there was a 12-year-old boy killed by someone who thought he might have been an invader when he was playing Nicky Nicky Nine Door. You hear stories about people who are mistaken for invaders, who are delivering packages. What we're saying is where there is a set of circumstances that is unreasonable, the police should be able to make an independent decision. The law that was put in place by Stephen Harper, and it's a law that I actually support. You have the right to defend yourself in your home. I would remind colleagues that we have an opportunity to discuss the hate legislation that we brought forward. I hope subsequent questioners will take that issue as seriously as the government does.
Thank you, Minister. MP Housefather, the floor is yours.
Thank you.
No, it's fine. You used this time. Anthony, it's all yours. Yeah.
I believe Ms. Dillon wanted to go first, so I'll give her the time. You're sure? Okay. Thank you, Mr. Minister, for coming here, and thank you for. I was a little bit surprised and a bit disappointed to hear Mr. Brock categorize this legislation as something that restricts free speech and minimizes its importance. This is legislation that comes forward after a shocking rise in anti-Semitism in Canada over the last 2 years that has led many in the Jewish community to feel very, very unsafe in the country. And last year, at my request, this committee, and Mr. Brock was there at the time, Monsieur Fortin était là aussi, we did a study that was called Heightened Anti-Semitism in Canada and How to Confront It, that came forward with many recommendations, some of which are included in the bill. For example, Minister, you're aware of the study on anti-Semitism the Justice Committee did last year?
Yes, I am.
So recommendation 10, that the federal government, that the federal parliament consider creating a new intimidation offense under the criminal code to more clearly and directly protect entrance to and exit from community buildings and worship and houses of worship and community centers, in addition to existing offenses that may apply in situations where such buildings are being blocked. Mr. Minister, is that in the bill?
It is, and I would note that recommendation had multi-partisan support, including from the Conservative Party.
And then recommendation 15, and in addition, you've also added an obstruction offense in addition to the intimidation offense that the committee had recommended. Recommendation 15, that the Government of Canada consider removing the requirement to obtain the consent of the Provincial Attorney General in order to prosecute certain hate crimes. Mr. Minister, is that in the bill?
Yes, again, that recommendation was supported by multiple parties, including the Liberal and Conservative parties.
Recommendation 16, that the Government of Canada take steps to ban the display of symbols of terrorist organizations that are listed under the Criminal Code. Mr. Minister, is that in the bill?
At risk of repeating myself, it's in the bill. And again, I reviewed the recommendation with sincerity and realized it had multi-partisan support at the time. I'm disappointed to see the tune has changed.
Recommendation 17, that the Government of Canada work with police forces across the country to develop a standardized definition of hate crimes and hate incident. The standardized definition of hate that was essentially referred to in that recommendation, essentially is in the bill as well. Is it not, coming from Supreme Court jurisprudence?
Absolutely.
So looking at the fact that for the last period of time there's been a lot of people, myself included, that have criticized the words that have come out and a failure to act, is this bill not exactly what was being requested in terms of actually acting in terms of what the federal government can do within our own jurisdiction to respond to the incredibly high rise of anti-Semitism and other forms of hate in the country?
Certainly. That was a major motivator to take action in the first place. And I should say, Mr. Housefather, thank you for your work on the committee and more broadly to advance measures that would combat hate in our communities. The process of developing this legislation relied heavily upon the work of parliamentarians from different parties to inform the final version of the bill. We did not seek to turn this into a partisan affair. My hope was this would cruise through the parliamentary process with support of all parties in the House. I still hope we can get to a place where that remains the case.
I certainly do too. Minister, I want to ask you something that's part of the bill but a bit auxiliary to it, which is the fact that in this country there's different jurisdictional issues which the committee ran into when we were doing this report, and que le Bloc québécois a soulevé à multiples.
The Bloc québécois raised on a number of occasions. It's a provincial area of jurisdiction.
Many of the issues that have preoccupied people, the demonstrations that have happened, including demonstrations on October the 7th in Toronto and Montreal, shutting down Concordia University, involved what many believe to be disrespectful actions versus necessarily illegal ones. You said something very, I thought, apropos at your press conference about setting a tone from the top about what this country expects versus what is illegal. But politicians have to set a tone, and what we don't think is Canadian is our values. Could you sort of repeat a little bit about what you said at that press conference?
Certainly. Canadians want to see leadership when it comes to treating one another equally. And Canadians want to see leadership when it comes to combating hate in our communities. We wanted to play a leadership role by introducing legislation that would criminalize behavior that crosses a high degree of moral culpability, that threshold that brings something into the criminal context. But we should similarly recognize that there are many acts that we may find offensive that do not constitute hate for the purpose of the criminal code. We should nevertheless endeavor to condemn those acts, because the impact that a failure to speak out against hate it takes in our communities is still a negative impact that our fellow Canadians feel. We need to demonstrate leadership through our legislative action, but also in our words and in our deeds when it comes to condemning acts of hate or discrimination whenever they take place. And I think it's incumbent upon all of us, regardless of party, to speak out and to advance measures formally and informally that will have that impact, demonstrating that all Canadians belong in this country.
And I think one of the frustrations has been that existing laws have not been enforced by municipal police, by those authorities on the ground. And the point has been made that, well, the federal government should tell them to enforce the existing law. But of course, the federal government has no power or jurisdiction to tell local police how to operate operationally on the ground in our cities, whether it's Toronto, Montreal, or elsewhere. But do you not believe that this law is sending a signal to provinces and municipalities and police as to what the federal government is expecting in terms of a tone from the top and in terms of enforcing the law?
It does two things. It both sets the tone, as you've indicated, but in addition, it also makes it technically easier for police to do their job when it comes to laying charges by providing clarity in the definition and removing the procedural step of requiring the consent of the Provincial Attorney General, both of which will add to the tone-setting exercise the bill may represent by actually making it technically easier to lay charges in the real world.
Thank you so much.
Merci, Monsieur Ambassadeur. Monsieur Fortin, la parole est...
Mr. Fortin, the floor is yours. As usual, 6 minutes to start off, please. Well, thank you very much, Mr. Chairperson. Yes, good afternoon, Minister. Thanks for being with us here today. Minister, there are some aspects of C9 I'd like to look at with you, but I'd like to start with one that really jumped out at me. It strikes me that the provisions under C9 to combat hate and anti-Semitism, etc., already exist in the criminal code. Now, I understand that we're not talking about exactly the same text, but there are already provisions, for example, that state that whomever foments genocide is committing a criminal act, who is inciting hate, who is fomenting hate, anti-Semitism, and so on and so forth. Who is causing harm or hatred, another offence at 340. So I'm not going to list all of the provisions exhaustively, but the fact remains that most of the situations that C9 is intending to legislate on, they already exist. Why did you deem it necessary to introduce legislation that substantially is a copy and paste of the criminal code? Response. Well, I understand your point, but I don't agree with it. There are new offences such as intimidation and obstruction. Let me use one example by way of response. You need to understand that the penalties change when we add these criminal offences for hatred. When what motivates the hatred is the colour of someone else's skin, well, we need to have tougher penalties. Moreover, we need to recognise the impact not only on individuals but on the entire community affected. Now, there's a new offence for willfully promoting hate.
we wanted to recognize that sometimes the tool you use to commit a crime makes it more serious. You can think of assault and assault with a weapon. It still would have been criminal before you used a weapon, but it recognizes the harm can be greater with the tool that you use.
But does that mean that the offences in the criminal code were not up to the task? They weren't up to snuff? For example, fomenting hate. There's already a penalty attached to that. It's all well and good to add 6 months or take away 1 month, but at the Bloc Québécois, we proposed legislation in the last Parliament that proposed to, in fact, eliminate those offences for religious reasons. And one might be able to complain to have a solid defence if one's actions were on the basis of a religious text. I can't see that in C9. Would that not have been useful? Possibly. Now, I am interested in hearing evidence on that, and if the majority of members of this committee are in favour of it, won't be an issue for me. But when I look at the current exception, there is an obligation for good faith. And if someone's using religious reasons to foment hate or as a reason to kill others, that's not justifiable. But I would, of course, consider any recommendations issued by this committee, and perhaps you might wish to make an amendment, in which case the committee can amend the legislation. Thank you, Minister. Perhaps an amendment's all well and good, but I would have liked to have seen it in 6C9 because, you know, we have very little time in committee to deal with things that are self-explanatory or obvious. When in good faith one expresses an opinion on a religious issue or on a religious text that that individual believes is legitimate on the basis of their arguments, that strikes me that it has no place in the criminal code, that offence in 2025. But it would have been my fond hope that you share my opinion. Now, at a press conference, you said there are about 5,000 hate crimes annually. Of that total, how many have been prosecuted? Are you aware?
Yeah, I don't have the numbers of prosecutions in front of me. We'd be happy to provide that information on the back end or perhaps with officials in the second half.
À votre avis, Monsieur le Ministre?
In your opinion, Minister, were there as many prosecutions as hate crimes committed?
Expect not.
Expect not to. Et je me demande si...
And moreover, I wonder if the defence on religious exception has something to do with there weren't as many prosecutions as crimes committed, because the Crown prosecutor needs to determine whether they will prosecute, and in doing so they have to ask the question, will the accused have a reasonable defence to make? So I would suggest that you think long and hard about that offence based on religious exceptions, and that might be a wise thing to do. Now, I have very little time left. The definition of hate in the criminal code, is it too broad? Is it too narrow in relation to what you're proposing under 6C9?
The definition that we're proposing, I think, strikes the right balance. We wanted to respond to calls from law enforcement for the need for clarity, but this was not an attempt to change the definition that existed from the jurisprudence that came from the Supreme Court of Canada. It was designed instead to provide clarity to those who are actually enforcing the law on the ground based upon the existing body of case law.
Merci.
Yeah, wait.
Mon temps est fini?
Wait.
Your time's run out. Yes, my time's run out. Thank you.
Première ronde and the second. 5 speakers. Mr. Baber first for 5 minutes. Mr. Chang for 5. Mr. Fortin, 2 minutes et demie, comme d'habitude. Mr. Lawton, then 5 minutes, and then MP Dillon. Mr. Baber, the floor is yours.
I represent one of the largest Jewish communities in the country to which I also belong. Over the last decade of the Liberal government, hate crimes against the Jewish community have more than quadrupled. I believe that your appearance today is evidence of your government's failure to protect the Jewish community. To add betrayal to injury, the Prime Minister rewarded the worst terrorist attack in our lifetime with the recognition of a terrorist state. So please don't pretend that you're doing us any favors. But what I am seeing is that unless Bill C9 is amended, it will criminalize and prosecute speech that isn't criminal right now. So let's get into it. For 35 years, we used the Supreme Court definition of hatred from a case named Keegstra. It is an emotion of intense and extreme nature that is clearly associated with vilification and detestation. You say that you're trying to codify the Supreme Court jurisprudence, but your definition that you propose in Bill C-9 is the emotion that involves detestation or vilification and that is stronger than disdain or dislike. You removed the words intense and extreme nature from the Supreme Court definition. Why are you trying to lower the bar to charge and convict people of hate speech? Is it to criminalize speech that liberals don't like?
No, and I'm just curious, in the preamble to your question, you indicated that there is additional hate speech that may not be criminal. And I'm curious, is there certain examples of hate speech that you think should not be criminal?
No, I'm saying that we have a clear definition of hate speech from the Supreme Court, definition that your government is trying to dilute through Bill C-9. Why are you diluting this definition by eliminating the words of an extreme and intense nature?
So when I review the definition of hatred, not just in the Keegstra, but the Whatcott decision as well, it's clear to me that vilification and detestation are extreme manifestations. To the extent that you have a different interpretation, know that the intent of the legislation was, in fact, to codify not only those specific sentences in the decisions, but the different factors that the courts would have used over the years to identify. Should the committee feel that the legislation would benefit from a different reflection of the test that the Supreme Court has laid out, do know that that would not be a deal breaker for me, particularly if it would earn multi-partisan support and send a signal to Canadians that all parliamentarians want to combat hate in their communities. This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement.
It is doing exactly that. And in fact, the court in Whatcott has referred and reaffirmed the definition of Keegstra. I'm scared that you're going to use your proposed definition against Canadians and against members of the Jewish community. Your proposed definition is so broad, ill-considered by the courts, that it's probably unconstitutional. But should Canadians expect, like in the videos we're seeing out of the UK, that police are going to be knocking on their doors in the middle of the night for a Facebook comment?
Absolutely not, and I think the suggestion is patently far-fetched on the face of it.
All right. Bill C-9 will remove the requirement for the consent for the Attorney General to prosecute hate speech. The previous Attorney General said that the consent is a required safeguard. I heard your position during debate that in the future you may have a political Attorney General who will withhold consent to lay hate charges. But if the Attorney General can be political, then certainly a Crown Attorney can also be political, and a police force or a police officer can be political, and their judgment could be clouded politically, and they can potentially bring hate charges when it isn't appropriate and ruin someone's life. Have you considered that?
I've considered many aspects of this, and I like to start with the problem that we're trying to solve. We heard loud and clear from affected communities that charges were not being laid and justice was not being served. Stakeholders and, in fact, the Justice Committee had, including multi-partisan support, including your own party, have supported this particular change. I also hold the view, in addition to the argument that you've put in place, that with the extensive body of case law that has emerged over decades that has been informed the actions of law enforcement, the additional safeguard that the AG consent once provided is not as necessary today as it would have been back then. Wanted to solve the problem to ensure it was easier to lay charges where law enforcement can apply the law independently when they see hate in their communities in an effort to stamp it out everywhere.
It will be especially easier with you diluting the definition of hatred. But what's even more scary is that private prosecutions will also be exempt from Attorney General consent. Now, yes, the Crown may withdraw or stay charges, but the complainant could appeal either the Justice of the Peace or the Crown's decision to stay the charges and drag an innocent person into divisional court on judicial review. Do you really fail to see how allowing private prosecutions for hate offenses without the Attorney General's consent could be weaponized against innocent Canadians, including members of the Jewish community?
Mr. Baber, the time's up. Perhaps one of your members can pick that question up later. Thank you. Mr. Chang.
Thank you, Chair. Minister, Burnaby Central is one of the most diverse communities in Canada. So in 2022, someone shouted at me at Metrotown Scheduling Station. He said, and I quote, "What are you looking at, Asian? If you want to F-word, go to Davie Street. So as someone who has personally experienced discrimination based on my ethnic background and sexual orientation, I'm deeply concerned about the rise in hate crimes. However, I believe that it is equally important to ensure that Bill C-9 upholds and respects our charter rights. Minister, we have seen troubling rise in the hate-motivated incidents across Canada. Could you explain how Bill C-9 directly addressed the growing threat and why now is the right time for this piece of legislation?
Look, thank you. I too take very seriously the need to protect the rights of Canadians, but I take a broader view of what that includes. And in my view, it should include the right to actually live freely in your community, not just to have rights ascribed to you on paper. When we see hate take place in our communities and choose not to take action, we are complicit in hate's continuous fomentation. And I, for one, don't think that's acceptable. The changes that we're making to the criminal law are going to add real protections for communities of faith going to their places of worship, their community centers, their schools, for people more broadly to know that there will be additional charges, specific crimes of hate, if they are in fact targeted on the basis of their race or their sexual orientation, and to know that they will actually have changes made to the law so they are not a paper victory, but are likely to lead to more charges, and in turn that deterrent effect will have fewer instances of hate play out in their communities. This is about changing the real-world experience of people who should not be subjected to hate in this country, and I think it's incumbent on all of us to actually have that frame when we're adopting laws or considering what amendments we may propose to them.
Minister, we know that schools and youth spaces have increasingly become target of hate-related incidents. How will Bill C-9 help ensure that students, educators, teachers are protected from intimidation and hate?
So the bill it's really important. Although this conversation has largely played out around themes of protection of religious minorities, it has a much broader application. Schools that are designed for a particularly an identifiable group in Canada would certainly benefit from the protection on the intimidation and obstruction offences. But we also wanted to make sure that we capture hate more broadly, so that if someone is targeted, regardless of whether it is a school for a particular religious community, a particular community of interest, that you would nevertheless have the protection of the law where a criminal act is committed against a person on the basis of some immutable characteristic belonging to an entire group of people. This additional protection, whether it's in our schools, whether it's in our grocery stores, whether it's on our university campuses, is going to heighten the degree of protection that Canadians actually enjoy in their communities, no matter where they find themselves.
Thank you. La parole est à vous, Monsieur Fortin, 2 minutes et demie.
2.5 minutes, Mr. Fortin. Well, thank you, Mr. Chairperson. Minister, the Criminal Code states currently that the Attorney General needs to provide consent before prosecuting hate crimes. C9 will delete that prior consent. Could you please tell me what that previous prior consent, the purpose of was, and why delete it now?
At the time that the hate provisions were put in place, there were arguments made that formed their way into law that offered an additional degree of protection. The argument would have been to ensure that crimes had that second layer of approval before, in fact, charges were laid. In my view, given the fact the world has changed, the law has become clearer over many decades since the Keegster decision in particular, and law enforcement have gained experience, you no longer have that same need. We also, as a result of the rising prevalence of hate crimes in our communities, heard from communities more frequently that this is a problem that's getting in the way of charges actually being laid. I would make one final point, not to eat up your time, and if I need to extend by 30 seconds, I will. It's important to understand that provinces maintain the ability to implement pre-charge screening at their discretion should they wish. British Columbia, for example, does that for efficiency purposes. Other provinces could have the ability to do the same.
Merci, Monsieur le Ministre.
Thank you, Minister. I'm not the only one to think this, but with this prior consent, I saw it as a guarantee that the prosecutions would be serious when it comes to hate propaganda. If it's deleted, this provision, won't it allow an individual to prosecute or sue frivolously? when the Attorney General would not have given consent had he been obligated to do so.
So, and I think this touches on a question that one of the previous questioners put forward. I think it's important to keep in mind as well a difference between public Crown prosecutions and private prosecutions. There's a judicial screening process that will be in place to prevent the kind of frivolous or vexatious litigation that may exist. But when it comes to the Crown's application of the law, the law enforcement's application of the law in communities, I believe that they have the ability, based on the extensive body of case law, based on decades of experience, and based on training supports that are made available, to effectively police the laws as they're written on paper, so the outcomes we're seeking in communities can be fully realized by Canadians.
Time's up, Mr. Fortin. Well, I understand there's no good reason to delete that consent. It was useful. Well, I have a different point of view, but I understand yours.
Minister, thank you for being with us today. C9 makes reference specifically with hate symbols to public spaces. Just to confirm, does that include the internet?
Generally speaking, the law will apply equally online as it does in real communities.
So this bill will affect what people can say and write on the internet?
Just in the limited circumstances where there is the willful promotion of hatred against
It will apply
someone.
to the internet. The internet is within the jurisdiction of...
It would be possible that someone could commit a hate crime on the internet, certainly.
So, building off of Mr. Baber's points about the lower threshold for the definition of speech, there is, under this law, assuming Bill C9 passes, something that might not be legal to say today on the internet. Or it might be legal to say on the internet, could actually be illegal in the future under C9, could it not?
No, that's entirely inaccurate, and I say that with no judgment to your perspective, but let me explain. The only circumstance where you could imagine some online comment attracting scrutiny under this law would attach to behavior that is criminal today but would be punished less severely. The symbols piece that you pointed to, for example, is attached only to the willful promotion of hate. This is not a blanket symbols ban. The willful promotion of hate is a crime today, but we want to recognize a distinct charge where that same behavior uses certain symbols of hate to bring a higher degree of culpability. So there is no new human behavior that would attract the scrutiny.
I understand, but I'm building off of the discussion earlier on the definition. Is your view that the change in wording, and there was a change in wording, you made a deliberate decision to change the definition that was spelled out in Keekstra and reaffirmed in Watcott. Is your view that your definition in C9 will not capture anything beyond what is currently captured right now by the hate definition?
The definition was an attempt to codify, and the reason that there was a...
This is a yes or no question, Minister. Is there at all a lower threshold or a broader net on hate in Canada after C9 if it passes?
My view on the definition question, because the offences I would give a different answer to you for, but on the definition, my view is that it codifies the same behaviour that is there today, and it was meant to provide clearer guidance to law enforcement in the criminal code to apply the existing standard that has been recognised by the Supreme Court. Because
the same arguments that are being used by you and your government to push Bill C9 to protect people against hate, which on the surface sounds incredibly noble, but these arguments are the same arguments that have led to the United Kingdom having police literally knocking on people's doors over their tweets. So what guarantee can you give Canadians that we are not headed down that very road, especially in the context of other priority areas identified by you and your government, such as the Online Harms Act, which was introduced twice, actually, in the last two parliaments?
So this legislation is not identical in kind to the reforms that have been put in place in the UK, and we've actually looked at their experience and see that there are real challenges with how it's played out. For example, we've got a different approach where some jurisdictions around the world have adopted a more blanket glorification that could attract the scrutiny of a liking a Facebook post, for example, and we chose a different path. We instead tried to be very clear that we would not interfere with the charter rights of Canadians to freely express themselves, but at the same time time make it easier to lay charges where hate crimes are committed today. To the extent that you think there is a better way to clarify and codify the existing definition, do know that I believe in Parliament, and I don't care which party comes forward with these amendments. If it creates multi-partisan buy-in to codify the test, that's okay by me.
Can you guarantee that if C9 passes, no Canadian will end up being charged because of something they've posted on Twitter or Facebook?
Well, if they commit the crime of willfully promoting hatred against another person.
A crime with a definition that you're changing.
So, but it's possible that they could be convicted for what they willfully promoting hate online today. So certainly I would hope if someone commits a crime in the real world or online that they would face the appropriate criminal penalty if in fact it's captured by the code.
We had in my riding a very disturbing case a few weeks ago where someone had mowed a swastika, a Hakenkreuz I should say, into their lawn and was charged under the existing criminal code definition. They displayed a symbol. It was found to be willfully promoting hate. Law enforcement and the Crown agreed that they could lay that charge. So why is your bill at all necessary when we already have existing powers, which, to Mr. Housefather's point earlier, are simply not being enforced as often as they could be?
Look, this is an important question. I'll answer it very quickly. When you have the willful promotion of hate, the person who's convicted of that could still be convicted, but also of a second charge, the willful promotion of hate using hate symbols, which would attract a greater degree of culpability and potentially a greater penalty, recognizing that the use of hate symbols, when you're willfully promoting hate, can cause greater damage to both the individual and the entirety of the community. So I don't find these points to be inconsistent with one another, but instead that behavior could potentially face an additional charge with a more serious penalty because of the manner in which a person chose to promote hate to cause more damage to an affected community.
Thank you. Ms. Dillon.
Thank you, Minister, for being here today. In recent times, we've seen attacks on religious institutions, places that are sacred to people of faith who worship. Somewhere where they're supposed to feel safe and secure, they often do not. My question to you, and you've spoken about them being able to safely access these places of worship, and community centers as well. How will the new intimidation and obstruction offenses make that a reality?
Part of ensuring Canadians are able to be who they are and to live freely as a citizen of this country is ensuring that they can make choices about how they live their lives day to day, including how they practice their faith or participate in their community. A big part of that is how we gather, celebrate special occasions, and share cultures and traditions with one another. We have seen real-world challenges where groups who may have started out as being innocent protesters have escalated their behavior over the time, where they in fact may physically block people from attending the institutions that allow them to be part of their community, or conduct themselves in a way that is specifically designed to threaten another person from taking part in the activities that take place within those spaces. The spaces in which we gather in a country as diverse and multicultural as Canada are a big part of our cultural identity as a nation. We believe that the spaces that allow communities to fully celebrate their cultures and tradition deserve a degree of protection, and have found, in my view, an elegant solution that allows us to use the federal tools at our disposal to offer protections that allows Canadians to choose for themselves how they spend their days.
And if you can please provide some clarification, there has been misinformation on this bill saying that it bans protests near religious or cultural sites. Can you tell us what this bill can do to protect the right to peaceful protest? Because there has to be a balance.
Certainly, and I find some of the previous questions ironic in this regard. In fact, the argument is somewhat self-defeating. On the one hand, there's a suggestion that free speech is somehow impacted, and in the next breath, you hear the question suggest that in fact it doesn't represent a change in the law. And those two positions cannot cannot possibly be reconciled. When we developed these pieces of legislation, it was a priority to ensure that we didn't have a negative impact on the ability of Canadians to fully enjoy the rights that are protected by the Constitution, including the right to free expression. That's why, for example, when we wanted to deal with symbols of hate, we didn't use a blanket symbols ban, but instead attracted to the criminal behavior of willfully promoting hatred against another Canadian. There's a difference, in my view, from protesting a cause against some initiative, something that's happening in the world that you fundamentally disagree with, and showing up to intimidate a person from practicing their faith, or physically obstructing them from attending their community centers, schools, or places of worship. And understanding where that line exists as between sharing an opinion, broadcasting information, and causing harm, sometimes violent harm, to your fellow Canadians is an important distinction. And I think that this bill does a good job of scoping in behavior that I believe should be criminal, that will offer a greater degree of protections to Canadians to be themselves without infringing the protections to the ability to express yourself freely.
And because we need a good balance between freedom of expression and hatred. So this is one other question I have for you. You chose to have a clear definition of the word hatred. Why was this necessary to include this in the criminal code?
So law enforcement shared with me that a clear definition in the criminal code would help them actually lay charges when they see it. Eliminating ambiguity in the code can change how the laws are applied on the ground, even where they don't necessarily change the substance of the law that underlies the proposed amendments to the code that we're talking about now. In addition, I think it's essential that we recognize that this cultural impact within law enforcement has a real-world effect on the ability of Canadians to seek justice when they are, in fact, subjected to hate, not just on behalf of themselves, but on behalf of an entire community. So by codifying the principles that were recognized in the Keekster and Whitcock decision, we have an opportunity to send a clear signal to law enforcement that you can, in fact, enforce these crimes when you see them, and it gives victims of hate crimes a sense that justice will prevail at the end of the day.
Thank you, Ms. Dillon. Thank you, Mr. Fraser. We have time for Mr. Bever and Mr. Gill that will be splitting some time, Ms. Latanzio, and then we'll go to MP Edlow. So the floor is yours.
Thank you, Chair. Minister, you have said that Canada is not the Wild West. Yet, meanwhile, violent crime is up 55%, sexual assault 76%, extortion has surged. Extortion has surged by 330%. How bad does it have to get before you admit that Canada currently appears lawless?
Well, when I look at some of the proposals that we've seen put forward by your party on the House of Commons, it becomes clear that copying and pasting the American approach to criminal laws or to guns would not enhance public safety. The Conservative policy of wanting to legalize assault-style weapons, I think, would make Canada a more dangerous place. The repeated introduction of reforms that certainly violate the Constitution would not make Canada a safer place. And the example given earlier has led to a whole series of behaviors, including recently in the state of Texas, the accidental death by gun violence of a child who was ringing doorbells. It's obvious when you look at some of the proposals that have come forward that we need to have evidence-based policies, and that's what you're going to see with the bill that we put forward in a number of weeks to help change Canada's criminal laws to make our country a safer place.
Minister, many of the offences in C9 restate conduct already captured by existing criminal code. Provisions such as Section 423.1, intimidation, 319, public incitement of hatred, and 264, harassment. Would you agree that the core problem today is uneven enforcement of current laws, not a lack of legislation? What evidence did the department rely on to conclude that additional offenses rather than improved enforcement were needed?
I think both are needed. I take your point that enforcement can be improved, and sometimes that will be with more officers on the ground. Sometimes it will be with enhanced training. But I do think that we could have better and more equal enforcement of laws that do exist on the books. But I also think, based on the feedback that we've had, not just from law enforcement, but from affected communities, that these changes are necessary because you can recognize the significant difference when a person may assault someone because they have a disagreement that goes sideways versus specifically targeting someone on the basis of their religion or the color of their skin, which doesn't just impact the individual victim, but the entirety of a community. We believe that warrants, though it may be the same behavior in the instant, the effect is not the same. And we think that greater harm that befalls on a community demands a new charge with increased penalties to recognize the severity of the impact of hate crimes on affected
Minister,
communities.
I cede my time to Mr. Weber now.
Thank you. Minister, do you really fail to see how allowing private prosecutions for hate offenses without the consent of the Attorney General could not be weaponized against innocent Canadians by vexatious litigants or political opponents?
I have a lot of faith in the ability of courts to police frivolous and vexatious litigation. You see the opportunity for courts to screen out those kinds of complaints with great frequency. If the committee wishes to take evidence from experts in the space to understand the protections that do exist and where it can be improved, do know that I don't come into this with some preordained outcome. I believe in the work of Parliament. I believe in the ability to take evidence from witnesses and to propose amendments, and would consider each of them in good faith should you wish to move forward with some.
I also have a lot of faith in the courts. The problem is that by the time you get through due process, you may be taken through litigation, your reputation may be ruined, you may incur a lot of legal fees. So this is a major concern for myself. With respect to the new hate offense, the new criminal hate offense can be laid on top of any offense under any federal law. Is that correct? Yes or no?
Yes.
And so an offense under the Elections Act or an offense under the Canada Labour Code may attract criminal prosecution. Someone, for instance, could be charged criminally for non-payment of wages under the Canada Labour Code. Isn't that correct?
I have a hard time understanding how non-payment of wage, if there's a motivation of hatred towards another individual and you commit a crime against that individual because of who they are, it could attach to virtually any charge. The likelihood it would come up in that set of circumstances, I think, would be quite small.
You're basically talking about tacking on criminal charges on what is otherwise civil, non-criminal behavior. This is very concerning. You may have unintended consequences when you combine that with dilution of the definition of hatred, as you're doing, and the possibility for private prosecutions without Attorney General consent. This is a very concerning piece of legislation, Minister. Thank you.
Time's up. Perhaps Mr. Housefather can let him continue, or over. Either way, it's over to you, Anthony, for 5 minutes.
Thank you so much. Minister, I don't know if you had a chance to read the Conservative Party's dissenting opinion in the anti-Semitism study.
Yes.
Did you notice that they didn't dissent on the issue of removing the consent of the Attorney General for prosecutions for hate crimes?
So specifically, when we were discussing which measures to include, the fact that there was multi-partisan support, not just on that item, but some of the others that you referenced, made it clear that there was an appetite amongst parliamentarians in Canada to affect these very specific changes. It seems the Conservative Party has now shifted their position when it comes to those measures that were designed to combat anti-Semitism after the recommendations came out of that report.
Yeah, it's exceptionally surprising to me, in fact. Can I ask a question? One of the things that has been pointed out are the two defenses that have been added for the display of hate symbols and creating hate through the display of hate symbols against an identifiable group. Why are those two defenses that I think are in Section 3.2A and B necessary, Minister? Because some people just believe, right, if a hate symbol is put up, you automatically need to prosecute. Why have you looked at that and found that these defenses are necessary?
Sorry, just which defenses?
The defenses to, for example, related to times that you could display a hate symbol publicly without necessarily being charged with an offense.
Yeah, look, there's many reasons why you may wish to pull out certain uses of these hate symbols. Think of journalistic purposes, academic purposes, but also to prevent free expression. It's really important that we understand at this committee that this is not a blanket symbols ban, but is instead a crime of willfully promoting hate against an identifiable group through the use of hate symbols. This is a very high standard that does not trample on people's people's free expression rights, but recognizes specific learning opportunities or public interest opportunities where we can openly discuss where these symbols have been used over the course of our history.
Exactly, where it would be context specific.
Absolutely.
For example, you yelling and screaming slogans like globalize the Intifada and carrying terrorist symbols of the organization like Hamas that says globalize the Intifada would be one thing versus somebody simply putting a symbol in a museum or somebody putting a symbol somewhere to teach somebody about that. So I understand you can't pronounce on any of these, nor can any of us, because it's all context specific, but there is a reason why these exceptions are there.
Yeah, absolutely. And the circumstance you gave would be obviously differentiated from, for example, teaching kids about the Holocaust in our schools and learning the impact that these symbols had that caused an entire nation of people to turn against an entire group of people, leading to millions of Jews being murdered during the Holocaust. These are important parts of our history to understand, but they are not important in terms of our ability to protect the ability to use them to foment hate against others.
Totally agreed. And Minister, you had said something else in public comments that you had made, I believe it was at the press conference, about the idea that the intimidation and obstruction offenses that we can put into the criminal code are different than what municipalities and provinces can do in terms of bubbles around these types of buildings because they have zoning powers that we do not have. But you had also said that you might be reaching out to municipalities to inform them, such as the Federation of Canadian Municipalities that represents municipalities, what their powers are. Is that something that you're planning on doing?
Yeah, and in fact, we've had significant engagement leading up to the adoption of or the tabling of this legislation. But we have a continuing conversation with municipalities through FCM and other channels to ensure that they understand where their authorities lie to regulate what behaviors may take place in a space. We have a rather blunt instrument in that regard, in this instance, the criminal code, but we still think it can be deployed to touch hateful criminal behavior, no matter where it takes place, including around our religious institutions, but more broadly in our communities.
And I'll just finish off by saying, Minister, I think this legislation not only sets an example by the federal government, it will make Canadians safer by giving additional tools in the toolbox to police and prosecutors that they've requested, but it also sends a message to provinces and municipalities and police that we believe, and universities, that we believe they should be enforcing their rules and the law. And I thank you for being here today, and thank you for your comments.
Yeah, my pleasure. And obviously, it goes without saying that there's no one level of government that's responsible to combat hate. Federal governments, provincial governments, municipalities, and Canadians more broadly have a responsibility to be better neighbors. We cannot fail one another in this country and expect to overcome the challenges we're facing. It's time that we change our approaches and recognize that we have to speak up to end hate in our communities at every level of society.
Thank you, Minister. As agreed, we have MP Ed Load on the line, and she has 5 minutes. The floor is yours, Laurie.
Koyanami Ixibautari, Koyanami Katima Yagarat, Ilautitauga Matak Saminga, Pimmagerangmin. Thank you, Chair, and thank you to the committee for including me on this important study. I will be asking three questions, three sets of questions, three different topic areas. But I first want to say that I very much appreciate that Canada is such a diverse country. We have great diversity, and with this diversity is from a country that was founded from stealing and taking from Indigenous peoples. Indigenous peoples were on these lands before Canada became a country, and decision-making and governance was taken from us. So my first question is very much related to the treatment of Indigenous peoples. And so on trusting police, and just so you know, Minister, I'm going to ask all my topical questions to you in one statement just to ensure that I get all my questions on the record. And if you don't have enough time to answer my questions, I hope that the committee allows you to provide the rest of your responses in a written format back to the committee. My first topic is on trusting police to not abuse their power. New Democrats are concerned with giving police more subjective power to lay hate crime charges, a main concern being about trust. on a separate but related issue, Wet'suwet'en land defenders were criminalized. Nunavut land defenders were on the verge of being criminalized. Why? Because they were protesting government decisions. These are examples of deep level of distrust of police forces in Indigenous communities. You'll recall that about a year ago, this time, the Speaker had granted my request for an emergency debate on law enforcement because RCMP have enforced colonial and genocidal policies to oppress Indigenous peoples for decades. For about a week in 2024, between August 29 and September 8, Canadian police killed 6 First Nations people. Racialized people in this country have a similar experience with law enforcement. This bill requires Canadians to trust that the police will not know when an action is motivated by hate and when it is not. Could the minister respond by sharing what safeguards will protesters have that ensure that law enforcement does not use these new powers to criminalize protesters? On the second topic, on the stigma related to being charged by hate crime, hate is already an aggravating factor under the criminal code. This bill lengthens existing criminal code violations based on hate. In addition, the new offense puts the consequences of hatred at the beginning of the judicial process instead of at the end, when the sentencing judge has all the evidence and the accused has received due process. Being charged creates stigma as it is. This bill has the potential to create more stigma, troubling, especially when charges are dropped. Does the minister agree that keeping the Attorney General's consent in the process is an important safeguard to ensure that the justice system does not get flooded with increased charges in the already overburdened justice system? Does the minister agree we do not need to create more stigma and more hate in Canada? On the final topic, on the vague language in this bill, New Democrats are concerned with vagueness in this bill. We know that once broad definitions are codified, they can easily be weaponized against groups. For example, how will intimidating behaviors be interpreted by police? In its current form, this bill has the potential to criminalize peaceful protesters and legitimate dissent. We remain disappointed that this bill does not address the violent activities of the growing white nationalist movement. The failure to include the aspect in this bill leaves racialized communities, Indigenous communities, and the 2S LGBTQIA+ community without the necessary tools to combat the largest source of hatred in Canada. This bill seems to be more about criminalizing people who speak out than it is about addressing the growing racism against racialized people. Can the minister explain why this bill does not address the threat of the growing white nationalist movement in Canada? Thank you, Chair.
Thank you, MP. And Minister Fraser, you won't have any time to respond to this, and let alone, much less in a meaningful way. But if you undertake to provide perhaps written answers,
I'm willing to answer now if you would like, or I would comply with the request to provide
it's really
written
up
answers.
to the committee to decide whether
in writing.
Yeah. So I think
Okay,
the preference would be.
Laurie, thank you for your questions. The committee's requested due to time that I respond in writing rather than in person. I'll be happy to offer my thoughts on your very specific questions, and it's good to see you as always.
We'll let the minister go. And
Sir, to hear this.
Is it a point of order?
It's a procedural point of order, yes.
Thank you. Go ahead.
Thank you, Chair. We are concerned about the minister's earlier testimony to Mr. Housefather. He seemed to have relayed testimony that would have been taken in camera. Unless the minister can provide any basis for that testimony, I would reserve the right to come back on this issue as a matter of privilege. Unless the minister can provide any basis for that here right now. And to give you an example, we've got a transcript of the proceedings. Very early on, Mr. Housefather asked the minister, recommendation 10 stated that the federal government that the federal parliament consider creating a new intimidation offense under the criminal code to more clearly and direct protect entrances to and exits from community buildings and houses of worship and community centers, in addition to existing offenses that might apply when such buildings are being blocked. Mr. Minister, is that in the bill? Minister responds, it is. Minister then says, and I would note that this recommendation had multi-partisan support, including from the Conservative Party. Now, the minister was not part of the Justice Committee and would not be privy to this confidential information unless it was shared by a member of the Justice Committee directly to the minister. This is a serious breach of privilege. It is a serious breach of confidentiality. It is extremely misleading for both Mr. Housefather and the Minister of Justice to conclude, and this was just one example of many examples, where the conclusion drawn was that this was in full support by the Conservative Party. No one mentioned that the Conservative Party filed a dissenting report. And in that dissenting report, there was a strong statement that while the Conservatives supported most of the recommendations, there were other recommendations we did not agree with, hence the basis of the dissenting report. But on the issue of this confidential breach of information that was taken in camera, I'd like to hear from the minister as to how he acquired that information.
Thank you, MP Brock. It isn't up to the minister to respond unless he wants to right now. I am more than willing to take this under advisement and review the blues. As you well know, the report was submitted to the House, I suspect with your dissent as well, as is customary, but willing to review it. And should you raise the point of order, you didn't raise the point of privilege, but you obviously reserve the right to, in your discretion, raise that point of privilege at any point in committee and do so at a later date, but perhaps after we've reviewed the evidence. Unless anyone else wants to speak on this point of order, I'll take it under advisement and revert to the committee. Mr. Housefather.
Point of order.
He's speaking on the
Sorry.
point of order.
Well, the minister was raising his hand to respond directly, and I just didn't think you saw it. That's why I was pointing it out, Chair.
Up to you, Minister. But I saw Mr. Housefather, and then
procedure. We had a member who was in the middle of an intervention. I don't want to interrupt.
I defer to you.
Up to you, Minister.
Okay. Look, the information that we had was based on the public report. There was a dissenting report. The dissenting report didn't flag opposition to the specific recommendations that we had gone over. This was not, for what it's worth, I've not discussed who voted which way with Mr. Housefather, if that was the implication.
Okay. MP Housefather.
Yeah, the same thing. I did actually specifically refer in my second question to the Conservative Party's dissenting report, in which the Conservative Party dissented on DEI and noted that this was not a recommendation that they said that they dissented on in their report. And I think that is public information because it was in the report. Thank you.
Yeah.
I got the transcript right in front of me. And with all due respect to Mr. Housefather, the second question that you put to the minister made.
My second round of questions, Mr. Brock. My second round of questions.
Okay. I thought you said the second question.
No, second round of questions.
Okay, I don't have that transcript in front of me.
Perhaps we do take the time to review it, and we'll get back. The clerk will get back to you with his review of the blues. You're free to look at them yourself. And Mr. Fraser.
For clarity, I have not had any discussions with any members of the previous committee who generated this report about which parties voted which way. My comments were a reflection of the dissenting report, not including opposition to some of these measures. I have not had a single conversation about which parties voted on specific recommendations on the report that we're discussing today, and I just want to make that absolutely clear.
Well noted. Okay, thank you.
Thank you, everyone.
Thank you, Minister. And we'll suspend for a few minutes and come back with the second round of officials. Thank you.
resume. Time is running short. And as agreed, in the second hour, we have 3 witnesses from the Department of Justice. Owen Ripley, who was here in the first hour, Senior Assistant Deputy Minister, Joanna Wells, Senior Counsel, Criminal Law Policy Section, and Marianne Breeze, Counsel, Criminal Law Policy Section.
Statement, as is customary. If you did, we would limit it to 5 minutes. I see you shaking your head emphatically, so we will go directly to questions. We have, for the first round, the first 6-minute slot, MPs Gill and Brock splitting their time, and then MP Dillon, followed by 6 minutes from the Bloc Québécois. And I'll announce the second round as it arises. So, Mr. Gill or Brock, over to you.
Thank you, Chair. So my first question regarding the proposed intimidation offense includes a subjective test of intent and a relative low harm threshold. Is that threshold strong enough to capture genuinely threatening conduct, or could it unintentionally criminalize speech or protest activity already covered by Section 423.1? Was any consultation conducted with prosecutors or police to assess whether these new offense provides tougher penalties or merely duplicates existing tools?
Thank you very much, Chair. If I may, with regards to the question about the intimidation offense, what will be important in that situation is that police see evidence of an intention to cause a state of fear in another person. And so in order for somebody to be charged with that intimidation offense, their motivation has to be to cause a state of fear. So it's not a question of whether the individual trying to, say, access a place of worship or cultural center is afraid. We recognize we all have different kind of reactions of fear to different circumstances. What will be important is that prosecutors and police see evidence that the intention on the part of that person was to cause a state of fear to prevent that person from accessing that place.
May I ask Ms. Wells to comment on that?
Is there a specific element, Mr. Chair, if I may inquire, if there's a specific element that the member requires more clarification on? I would adopt Mr. Ripley's answer.
Okay. So I'll take that. I'll ask the next question. Historically, AG consent provides a supervisory safeguard ensuring hate propagation charges met the public interest and reasonable prospect tests. Why was that safeguard removed in C9, and what mechanism now replaces that oversight? Did Provincial Attorney General express support for removing this? And if so, which jurisdiction? Without AG consent, how will the department prevent inconsistent or politically influenced prosecution at the municipal or police service level?
Thank you so much for the question, MP Gill, and Chair, if I may. Important to recognize that the requirement to seek AG's consent is generally speaking, an exceptional condition in the criminal code. Most offenses can be laid without AG consent. As the Minister highlighted in his testimony, there is concerns that requirement has been acting as a barrier in some circumstances to police laying charges with respect to the existing hate propaganda offenses. That being said, there are still safeguards in place to ensure that there won't be abuse of that power. And so, for example, provinces do, as you highlighted, have a degree of discretion to put in place appropriate criminal procedures within their jurisdiction. And there are provinces that do that to require pre-charge screening in all cases, and that's their prerogative. And provinces, to the extent that they feel that there are safeguards that are needed, could put those procedures in place. And then with respect, when I was listening to the exchanges earlier, with respect to the issue of private prosecutions, there is a safeguard in place to ensure that if a private prosecution is coming forward, there's a mechanism to ensure that there is a screening that private prosecution isn't frivolous or vexatious, right? So there's an ability for a judge to make that assessment, and if it was being brought forward in bad faith because it's frivolous or vexatious, they could ensure that situation is dealt with.
I cede my time to Mr. Brock now.
Thank you. Thank you, officials. And this question can be answered by any particular official. I like clarity when it comes to criminal law jurisprudence and interpretation, and I'm troubled by a couple of aspects to this bill. On the issue of symbols, you've indicated in respect to 2.2 sub C, a symbol that so nearly resembles a symbol described in paragraph A or B that is likely to be confused with that symbol. That is just fraught with subjective interpretations. It's going to be a minefield in litigation, leaving aside the confusion for police officials to determine whether or not, in their view, it is a symbol closely resembling a symbol that is tied to a listed entity. Why did you use that language, and was that directed by any particular group that you consulted with?
Thank you so much, MP Brock, for the question, and Chair, if I may. Just briefly before I address your specific question, MP Brock, I would highlight that the objective of listing those symbols, so the symbols associated with a terrorist entity or the Nazi symbols that are listed, it recognizes that there is often a nexus of hate associated with those symbols in the way that they can be used in certain situations. And as I imagine you are aware, and as the Minister highlighted, it's not a simple public display offense in this case. There are a variety of
No, I get that.
The time's up. I'm just hoping you can finish this thought quickly.
Well, I'd like him to answer the question that was put to him.
So the specifically subparagraph C, Minister Brock recognizes that the element of offense of the symbol, if there is simply a minor modification to the swastika or the Hakenkreuz, for example, that should not necessarily exempt that activity.
Thank you, Mr. Ripley. Thank you. That time's up. MP Dillon.
How the new hate crime offense would apply to existing criminal code offenses. The minister explained about hatred and how it's different from treating hate as an aggravating factor during sentencing.
Thank you for the question, MP Dillon. The objective of creating a standalone hate offense is to denounce all hate-motivated crime. And so what it recognizes is that it would be open to police and prosecutors at the beginning of an investigation to charge somebody with any kind of hate-motivated crime. So, for example, if you had the crime of uttering threats or violence, if there was evidence to suggest that it was hate-motivated against an identifiable group, they could charge that crime as hate-motivated. And again, the objective there is to denounce that there is an enhanced moral culpability, as the minister put it, associated with those crimes when it is hate-motivated. So that is done at the front end, and when they do that, that could, if the prosecution is proceeding on indictment, open up a higher range of sentencing that is available at the back end if they are able to make out the offense of hate-motivated. So that is is different than an aggravating factor that is only considered at the end of an investigation and prosecution at the sentencing stage. And again, the objective there is from the very get-go to recognize situations where there may be a hate-motivated crime and to prosecute them as such.
So right at the outset, from now on, it would be considered hate, the word hatred, when filing charges. And that's another question I have. The Attorney General, the consent is removed. Can you talk to us a little bit about that? There seems to be a lot of confusion around it, and what was the purpose behind this?
Yeah, thank you so much for the question. As I was indicating to some of your colleagues, the concern around AG consent is that it was potentially acting as a barrier in certain circumstances to police laying charges. And so the objective in removing it from the existing hate propaganda offenses, and it's not proposed alongside any of the new offenses either, is to remove that barrier and provide police the ability to lay those charges without seeking that AG consent. I've been listening again to the exchanges and heard the concerns around some of the concerns that may come up in that space, including private prosecutions, as well as discretion for provinces to put in place their own criminal procedures. And again, there remains sufficient flexibility for provinces to do that, and there are safeguards in place to deal with vexatious or frivolous private prosecutions.
And that was going to be my next question to you about jurisdiction. So from an implementation standpoint, how would they navigate this, and what guidance or coordination would be needed with provinces and territories and municipalities to proceed with a consistent application of the law under this bill?
Yeah, thank you so much for the question, and Chair, if I may. So the government recognizes there are important considerations at play when it comes to implementing criminal code offenses, and it's critically important that police and frontline officers understand, the elements of the offense, how you identify them, and so that will remain the government and other bodies have been doing a lot of work in this space. What comes to mind, I think of, for example, work of the Race Relations Foundation that has been doing a lot of work with police of jurisdiction across the country to better equip police forces to be able to identify the various elements of hate crime, to improve community trust in reporting hate crime, and to ensure that when police do receive complaints, that they take them seriously. And so all those efforts will remain important because, again, government recognizes that offenses on the book are only as good at the end of the day in terms of the people who apply them in a fair and consistent manner.
And already what exists in the criminal code, as opposed to what's in this bill, can you please walk the committee a little bit through the differences between what's already existing regarding hatred and hate crimes and what's in the bill, please?
Yeah, so thanks very much for the question, MP Dillon and Chair, if I may. And I heard the exchange about, are these changes necessary? Are there existing tools? I'll maybe deal with it in a couple of parts. So with respect to the intimidation and obstruction, the new intimidation and obstruction offenses, they are clearly responsive to an issue that is very top of mind for Canadians right now, which is the way that certain religious places of religious worship and cultural centers are being targeted. Jewish synagogues, Muslim mosques, I think we have all seen the evidence of that in the news stories. And so those offenses are a response to that. And at the end of the day, if Parliament was to pass the bill, are a recognition that that kind of behavior is serious and needs to be responded to in that manner by police and prosecutions.
Thank you, Mr.
Thank you so much.
Monsieur Fortin, pour 6 minutes.
Mr. Fortin, 6 minutes. Thank you very much, Mr. Chairperson. Mr. Ripley, earlier I asked a question of the Minister about the number of hate-motivated offences that occurred over the past year, for example, and the number of prosecutions. He didn't have the figures at hand. Are you able to respond to that question?
Merci pour.
Yes, thank you for the question, Mr. Fortin. No, unfortunately, I don't have those figures at hand either. And as the Minister mentioned, we have some data on the rise of hate crimes, and we took note of your interest in the matter so that we can look for figures on the number of prosecutions, and we'll go back and see if we're able to provide you a written answer to that question. I imagine that you're aware that one of the challenges we face in this area is that it is a provincial and territorial area of jurisdiction, but we'll take a look and see if we can get an answer for you. Thank you. Now tell me, Mr. Ripley, currently the way things occur out in the field is that the police officer might deem that a hate speech or anti-Semitism situation is at play and will see the Attorney General and ask whether that individual can be prosecuted. The Attorney General will think about all of that, factor in a number of elements and decide whether to go ahead or not, because there aren't grounds to proceed and because there's a strong likelihood of a defence that will win the day. Now, in your opinion, the defence currently in the criminal code on religious exceptions, and I know you know what I'm talking about when it comes to anti-Semitism crimes and hate crimes, in your opinion, will that defence in any way play a role in determining whether a prosecution can be launched? Well, thank you very much for the question. If I may, Mr. Chair. As a rule of thumb, when considering the possibility of prosecution, one needs to ask the question, is there a reasonable likelihood of a conviction on the offence in question? That's the rule of thumb. Of course, it's an overgeneralisation of the rule, but it's basically how things occur nationwide. And prosecutors therefore look at the various elements of the offence and what needs to be demonstrated in order to obtain a conviction. And in that process, they determine whether there is a likelihood of any such defence of that kind being invoked. Now, when one ponders those questions, there's an overall analysis that's conducted which factors in everything to do with the offence and any defence that may be made. Question, you're probably aware of the incidents that occurred about a year ago or just a little over that. An individual, Adin Chakawe, was in Montreal and he said something along the lines, and I don't want to put words in his mouth, but something about Allah. He incited hatred against Jews, about their extermination, not forgetting a single one of them. And I think that from the folks that I know, everyone considered that hate speech that was unacceptable, egregious, and everyone was convinced that that individual would be prosecuted and convicted, and yet the Attorney General decided not to prosecute. Now, the current exception in the criminal code for a defence on the basis of religious exception, would that provision perhaps have factored into the decision of the Attorney General? Response. Thank you very much for the question, Mr. Chair, through you, if I may. I can't tell you what was included. No, the question was, in your opinion, I know that you're not the one who made the decision, but in your opinion, that provision of the criminal code, did it factor in to whether or not a prosecution was possible? Response. Well, it's not up to us to make such a determination. Of course, we support the government when it comes to criminal offences, and I did, of course, read the media reports to do with that particular incident, but that question would be better asked. Well, as I said earlier, the situation would have been analysed to determine. Well, I'm sorry to cut you off. I just have 30 seconds left. I understand that you don't have an opinion on this, but Ms. Wells, do you have an opinion to share with us?
I think, thank you, Mr. Fortin, through the chair. Our role here, as you know, is to support the government and to share information about what the Bill C-9 would do. We are not well placed, as Mr. Ripley said, to opine on prosecutorial decisions that have been made or might have been made in other cases.
Le député Lawton en premier, 5 minutes, suivi.
Followed by MP Latancio, and then Mr. Fortin, 2.5 minutes. Then 5 minutes, and I think Mr. Cheng will have an opportunity to speak for 5 minutes if we remain disciplined. The floor is yours.
Officials for being here. Mr. Ripley, I'm assuming you're aware that the Liberal government has agreed to recognize the state of Palestine. Now, we know that Hamas, which is the de facto government in Gaza, waged the brutal October 7th attack on Israel. We know that in the West Bank, the Palestinian Authority regularly gives financial contributions to the families of terrorists. So as really by the Canadian government's definition now, a state sponsor of terrorism, could someone be charged under C-9 for waving a Palestinian flag under the symbols ban?
Thank you so much, MP Lawton, for the question, Chair. If I may, with respect to the offence related to symbols, what would be necessary to show is that it is a listed terrorist entity. So in this case, for example, Hamas is a listed terrorist entity, and the symbol in question would have to be associated with that terrorist entity. And so, for example, the flag of Hamas would be such a symbol, right? The flag of Palestine, for example, though, is not a symbol that would be likely to meet that threshold.
Not likely, but it could, for example, if the government designated it a state sponsor of terrorism?
Maybe just to take a step back.
It's okay. I'll move on and reclaim my time, but I appreciate that. Ms. Wells, I understand you're the senior counsel or a senior counsel in the criminal law policy section. How many people are in the department's criminal law policy section?
I don't have the exact number, but there are a number of lawyers.
And how many, as a rough percentage, were involved in C-9?
I think we have a core team of 4 lawyers with some support from other counsel and paralegals and analysts.
And were you working on C-9 full-time for the last several weeks and months?
We have very variable responsibilities, but it has taken a fair bit of time.
More than dealing with bail?
So I don't deal with bail, so my time hasn't been spent dealing with bail. It's not my area of expertise. For my colleagues who do deal with bail, as you can imagine, it's also a very busy area of policy development.
Would you say C-9 has taken up more of your department or your section's resources than dealing with reforming or fixing the broken bail system?
So in my position, I don't have the data around hours spent on various files. I don't know if Mr. Ripley would like to.
But it hasn't been a priority that's come to you. It has a government priority.
I think I would defer to Mr. Ripley as the Senior Associate Deputy Minister.
Mr. Ripley.
Thank you, MP Lawton. So I am responsible for the criminal law section. As the Prime Minister, or as the Minister has indicated, there is a lot of work ongoing in the space of criminal law reform right now, including with respect to bail and sentencing. And the section has been investing a lot of resources in advancing that work, in addition to Bill C-9, which is before us today.
Which has taken more resources?
I'm what I guess the way I would put it, MP Lawton, is the section is working full out currently to advance the government's criminal law reform efforts, which again, the minister has indicated are going to touch on bail and sentencing, gender-based violence, children protection, victims measures, delays. I mean, as you have heard the minister he set out a number of issues there, and we are working very hard to support the minister and the government more broadly.
Very simple question, please, Mr. Ripley. When did your work on C9 start, and when did your work on bail start?
Thank you for the question, MP Lawton. Chair, if I may, I would say, I guess I would characterize it like this. Once the government was elected, we work with the government and the minister to understand.
Which started first?
So the starting point for, after any election is looking at a government's platform commitments and
please don't run the clock, Mr. Ripley. I'm asking you, which did you start on first, Bill C9 or working on fixing the broken bail system?
What I'm trying to communicate to you, and I apologize if I'm not doing clearly, is there are platform commitments that touch on both, right? And so that work started simultaneously in both cases
at the same
to
moment
understand
you
their
started
platform.
both. Okay.
Thanks. Time's up. Thank you, Ms. Latanzio.
Thank you, Mr. Chair. Thank you, officials, for being here today, and thank you for all the work that you've been doing and are going to be doing. I want to come back on a point that was raised earlier with regards, and it's a point of clarification really that I have, with regards to attaching the offense of hatred on a civil offense. Now, can you explain to me how that would work? Because my understanding is that the offense would have to be of a federal nature. And so I'm not too sure I understood how that would work. Can you clarify that for me?
Thank you for the question, Parliamentary Secretary and Chair, if I may. The standalone hate crime offense would apply to any federal criminal offense, and that applies to the offenses obviously set out in the criminal code, but to the extent that Parliament has recognized other federal offenses and other pieces of legislation, and that happens. I believe the Election Act was cited earlier. You have the Immigration Refugee Protection Act. You have the Controlled Drugs and Substances Act. To the extent that Parliament has created an offense, and that is when you read an offense, if there is a penalty associated with that of a time of imprisonment, for example, that is inherently a criminal offense. And so when there is an offense in another statute where the situation is that it could be hate motivated, it would be open for that offense to be charged under the new standalone hate offense. But there is no situation where a civil, like a civil claim or something like that would be in play in this kind of situation. It is really restricted to, again, federal offenses in the criminal code or other federal statutes that fall under the government's criminal law head of power from a constitutional perspective.
Thank you. What are the key criteria or tests that the law enforcement or prosecutors would use to be able to determine what is displayed in terms of symbols and that fall within the scope of the proposed hate propaganda bill?
Yeah, thanks very much. I might turn to my colleague, Marianne, who perhaps Marianne might suggest just kind of walking through the various elements of the offense and what would have to be shown in terms of the symbols offense.
Thank you, Mr. Ripley. And so I guess as a caveat to begin with, I would say that every case would be dependent on the facts, and it would be up to, again, police and prosecutors to make this determination. But we would expect consideration to be given, for example, if we start with the offense, is it a symbol that is captured by the offense? And so if we're looking at the terrorism symbols, we'd ask, well, is it a symbol that is primarily used by or associated with illicit entity? That suggests that it needs to be publicly available. That list is public, and there has to be a close nexus to that entity. And then a prosecutor would then, if that is met, then we would look at, well, is it in a public place? So is it displayed in the street? Is it in a park? Is it on a website that is publicly available? If those elements are met, then we'd have to look at, well, is it being displayed intentionally to promote hatred against an identifiable group? Identifiable group is a defined term in law. It means a specific section of society, of population that's distinguished by certain factors such as race, religion, so forth. And then we would look at the promotion of hatred. And so we've been discussing there's a definition of hatred centered around the concepts of vilification, detestation. And then the courts have provided guidance on what that means operationally. So prosecutors would turn to the case law and look at, for example, what hallmarks of hatred would be. And then examples would be, is a targeted group being portrayed in a way as inherently evil, dangerous, for example. And then as a next step, you would look at what's happening on the ground, look at the facts. So law enforcement would see, for example, is the display being done on a street? Are there chants associated with it? Are there calls for the elimination of the target group at the same time as the display of the symbol is done? And so again, this brings us back to the situation that the symbol itself, there's not a ban on the symbol. The mere display of the symbol is not criminalized. It has to be situated within the broader elements of the offense.
Thank you, Ms. Breeze. Monsieur Fortin, 2 minutes et demie.
Merci, Monsieur le Président.
2.5 minutes. Thank you, Mr. Chair. The religious exception, you said you don't have any figures on the impact on the number of prosecutions. But can you tell me which groups were consulted before proceeding with the decision to not include this in C9, please? Response. Well, thank you very much for your question, Mr. Chairperson. There was a consultative process, a level of engagement over the years, and evidently this topic was discussed with the provinces and territories in the meetings, the usual meetings that we've had with those jurisdictions. On top of that, if I understood correctly, there was a consultations in 2020 that took place, and there was an undertaking made at that time by the parliamentary secretary, or rather engagement. Sorry to cut you off. I don't have much time, Mr. Ripley. Now, you said in 2020, but who was consulted back then? Response. There are several groups consulted back in the day. Religious and faith groups, community-based groups, civil society groups. Question: could you please undertake to send through the list of organisations that were consulted on this issue and on what date that occurred? Thank you, Mr. Ripley. Also, from memory, can you tell me recently the study on C9, was it taken into consideration? And if so, with whom did you meet? Response. Thank you for the question. The work behind the scenes on C9 was based on the consultative process, on the engagement that took place over that period. And as I mentioned, we consult our provincial and territorial colleagues. So the provinces and territories were consulted in 2025. Your time's run out, sir, unfortunately. Unfortunately, I'm not in control of the time. Two more questions. Mr. Chang and Mr. Bapus. Thank you.
Ms. Wells, in advance of drafting Bill C9, have you reviewed the Supreme Court's definition of the phrase hatred?
So I'm going to defer that question to either Mr. Ripley or Ms. Brees, who have more expertise in the area of hatred than I do.
Ms. Brees, have you have you reviewed the Supreme Court's definition of the phrase hatred in advance of drafting Bill C-9? Yes or no?
Yes.
The Supreme Court's definition of hatred includes the words emotion of an intense and extreme nature. Why have you dropped those words from your proposed definition of Bill C-9?
Thank you for the question. The definition reflects or captures the body of Supreme Court of Canada jurisprudence on the definition of hatred. The extreme and intense description is captured by the words vilification and detestation, as the minister had pointed out earlier. It is also clear that it is stronger than disdain and dislike. And so the definition, the intent is to capture the Supreme Court of Canada jurisdiction by indicating the high threshold of what is hatred and the narrow scope of it.
I don't agree with you that you can have a disdain or a dislike that's not necessarily extreme in nature or not intense in nature. And I also note that the definition is conjunctive. It's both intense and extreme, something that the Supreme Court has clearly articulated and is still good case law today. Were you instructed by the minister or any political staff to drop the words intense and extreme nature from the definition?
MP Baber, so thank you for the question. We want to be very clear on what the government's perspective is, and certainly,
please go ahead.
Have heard the concerns that you've expressed.
The question was: Have you been instructed by the minister or any of his staff to drop the words intense and extreme nature from the definition?
No, and the government's position in what it is advancing in the definition is intended to reflect the Supreme Court jurisprudence. That is what we are seeking to do.
You can have an intense and extreme nature for a positive emotion. You could be happy in a very intense and extreme nature. You could love a loved one intensely. So I would not necessarily say that just because you use two different words, such as disdain, that you necessarily meet the high threshold articulated by the Supreme Court. I'd like to go back to your point, Mr. Ripley, with respect to the screening process in private prosecutions. I agree with you. Yes, you would have a pre-enquête hearing where a judicial officer, magistrate, or a justice of the peace would either green light process to issue on private prosecutions or not. However, in almost all cases, the informant, so the complainant, would have an ability to appeal that decision to judicial review and take that to divisional court. And the accused is typically a party or an invited party to such a proceeding. And so even though there may be no cause for criminal charges to be instigated, the alleged accused would be dragged before the divisional court, would have to incur legal fees, would have to suffer reputational risks, time inconvenience, to be accused of a criminal charge. Don't you see how this potentially opens itself up to abuse, to ruin the lives of ordinary Canadians who should not be before a criminal court?
So thank you for the question, MP Baber. As we've highlighted, there are mechanisms to safeguard those frivolous private prosecutions. Acknowledge that they can, in that kind of situation, it can still have an impact on the accused. And I think you heard the minister. I think you heard the minister express an openness to hearing the committee's views on that point.
So you understand that there's no safeguard against the appeal of the pieces of justice decision, appeal to judicial review and divisional court. There's no safeguard for that, sir.
I hear what you are saying, that if an individual accused finds themselves in that position, that yes, there is an impact for that person.
Thank you. Finally, MP Chang, 5 minutes.
Thank you, Chair. Thank you all for your time. I'm just wondering, if Bill C9 is enacted, how will your department monitor and evaluate its impact, both to measure how effectively it addresses hate-motivated crime or hate-motivated offenses, and to ensure that it's fully consistent with our Charter rights and freedom?
Thank you very much for the question, and Chair, if I may. So the on charter compliance, the government is bringing forward a bill that it feels can be solidly defended, believes it strikes that right balance between charter rights and denouncing hate-motivated crimes. Of course, in any circumstance, it is always, open to an accused to ensure that the law is being applied in a charter respecting way, and nothing in this bill takes away from those safeguards. One of the benefits of the bill, if it were to pass, is that moving forward, there will be better evidence in terms of the hate-motivated crimes, because, again, it would allow police and prosecutors at the front end to make that assessment about where they believe, the elements of hate motivation are present, and to charge it as such. So again, in situations where you may have threats or threats of violence or those kind of things, that there's clear evidence it's hate motivated, it will allow Canada and Parliament to have a better understanding of that kind of criminal conduct over time.
Thank you, but internally, do you have any mechanism to monitor its impact?
Thank you for the question. As I was mentioning to MP Fortin, one of the challenges is that it's provinces and territories that are responsible, generally speaking, for the administration of justice, and so they often have the specific data holdings. There is a lot of work going on right now with our colleagues in provinces and territories to improve our national understanding of what is happening in the criminal justice system, and yes, those activities will continue, including in relation to hate crime.
Thank you. And can any of you please outline what each of the new proposed offenses would address and how they differ from the current offenses under the criminal code?
Yeah. So in response to MP Dillon earlier, I think I was talking about intimidation and obstruction and how that's very top of mind for Canadians. We ran out of time, and so I didn't get to the standalone hate-motivated crime. That one is a new offense, and again, the objective on that one is to recognize and denounce all hate-motivated crime, right? And so that is an important change, because it would allow that element of hate motivation to be brought to any charge or prosecution right from the get-go. And then finally, with respect to the proposed symbols offense, I described it earlier as recognizing kind of the nexus that those symbols have and the impact they have on certain communities, and recognizes that nexus with hateful conduct, acknowledging that the other elements, and my colleague Marianne did a good job of walking through kind of all the elements that you'd have to make out, acknowledging that you'd still have to make out all the elements of the offense.
Thank you. I have no further question.
There's a minute left if you want, and then we'll.
So what specific guidelines or guidance or prosecutorial discretion will be provided under Bill C9 to ensure that proportionality or proportional and consistent application across provinces?
Yeah, thanks very much. So there are certain steps that are being proposed in the bill, including, and we've talked a lot about the definition of hatred, putting in place that consistent definition that would apply, had some exchanges about kind of that notion of detestation or vilification. I would highlight, because it didn't come up a lot, that there is a for greater certainty clarification clause associated with the definition that is very clear that it does not amount to hatred solely because it discredits, humiliates, hurts or offends, right? And so part of what the government is seeking to do with that definition of hatred is ensure that there is a clear understanding and a clear threshold of when something passes into that kind of extreme manifestation or extreme emotion, right? And the way that the government has characterized that is through the concept of detestation and vilification.
Okay, thank you.
Thank you.
Thank you, MP Chang. I just want to take a moment we're at time, so thank officials for coming here and patiently taking questions and answering them to the best of their ability. So thank you for that. We're sort of over and around overtime. What we agreed to, I don't have tremendous amount to add other than happy Thanksgiving to everyone. On one point that we would like to emphasize is the witnesses for C9 are very much welcome for the next round. Please get them to us by midweek next week. We are complete on the bail and sentencing witnesses, so that's done. But we do need witnesses from all sides on C9. Thank you, and have a great.
When is the
Recap, Tuesday after the break week, we are
bail?
on bail.
Bail.
Back to bail.
Thursday, we're back to this.
Thank you.
Yeah,
Able to submit
let's do it by Wednesday.
by Wednesday?
Yeah. Thank you.
So I want everybody to hear that by Wednesday,
By
so they
Wednesday
know.
of
Chair,
next week.
just one quick question. So, our mandate and priority to Minister Fraser, will that be scheduled before studies have concluded or
We'll have
after?
to get to the ministers. We'll have to ask the ministers.
But that could preempt.
It could.
Okay.
Thank you.